Good morning, friends. Today I will share with you one practical experience on how intellectual property rights can define the course of your business. I will speak about a recent design infringement case which was filed before district court and then it got transferred to the Delhi High Court for final adjudication. I will take you through about various learnings for us so that we can avoid those mistakes and we can adapt our business operations in accordance with the law. We all are aware of the very fact that the marketing or the sales department of the organization is one of the critical department for the company. The growth of the company directly depends upon the numbers given by the sales and the marketing team. And most of the times, we are also aware of the fact that marketing or sales team is always under pressure to achieve their targets. They tend to push manufacturing team or legal team or R&D team to ensure that the products are launched in the market as soon as possible so they can be the first one to reach to the customer. Many times decision makers, founders get into the trap of early disclosure in the public, and that's where the blunder of disclosing in the public at the very first instance will give you nothing in the form of intellectual property protection. In this case also, the founders or the management did the blunder of disclosing in the public before filing any registration application. Without taking care of design application filings, the plaintiff company they launched their products on e-commerce portals, and subsequently after they learned that they should have also filed the design applications for obtaining the IPR protection. They were aware the product was already launched in the market before filing of the design applications. Yet they filed the design applications. However, they got the design applications registered also. Now, recently in the year 2019, when the plaintiff company got to know that there exists a prospective infringer who has launched the products of similar nature with respect to the registered designs of the company decided to issue the legal notice, and subsequently when there was no response by the defendant on the legal notice, the company filed an IPR suit before the district court in Delhi. Obviously, in any IPR case, the first step is to seek an ex parte ad interim injunction. In any injunction application, there are three parameters. First is prima facie case needs to be established. Second is that the balance of convenience should be in favor of the plaintiff. And third is if the injunction is not granted, then the plaintiff is going to suffer irreparable injury. Since it was an ex parte proceeding, the plaintiff got an ad interim injunction. So in any IPR suit, the next step for the defendant is to challenge the registration process. The defendants did their research. They came to know that the plaintiff registered designs were already available on the various e-commerce portals, and the date of publication of these products available on these portals is prior to the date of registration of these designs. So in other words, no novelty resides in the registered designs of the plaintiff company. And the rule of law is very clear on this aspect. If the design is already published and is already known to the public, then that design is not a new, not an original design. And hence, such design registrations are not entitled for protection. And this principle was used by the defendants to challenge the validity of the registered designs of the plaintiff on the basis that the products having such designs are already available in the market, specifically on the e-commerce portals by the plaintiff as well as the agents of the plaintiff. The defendant submitted a chart indicating a date of the availability of the product on these portals versus the registration dates of the designs. The plaintiff tried to enforce 17 registered designs, but not even a single registered design has the application filing date prior to the availability of the products having the similar designs. Though the suit is in the interim stage, the High Court make a prima facie observation that in view of the availability of the products having designs similar to the registered designs of the plaintiff, the interim injunction granted against the defendant is vacated. In addition to this, the High Court also ordered the e-commerce portal to give them the list of dates when such products were made available on their respective portals. So learning for the business owners, directors and decision makers is that even if you get the registration for such designs which were already publicly available, then at the time of enforcement of these design registrations, the validity of such design will always be questioned and the suit does not have any future. So key learning for us is that if we want to sell a product in the market, ensure that whether the product requires any design protection. If the answer is yes, first file a design application, only then launch the product in the market. Else you will not have any protection in the market, and if the product gets copied by others, you will have a tough time in the court to establish or to stop the copycats. Hope this information would add value to you, and I will bring more information about practical aspects in intellectual property rights, and be in touch. Thank you.